Welcome back. I'm Michael Bull, and this is the Commercial Real Estate Show, where we always like to have fun, right? We invited you to check out Commercial Real Estate Show TV. That's right. Visit YouTube. Search for the channel, Commercial Real Estate Show. Well, today our show is called Self-Storage 2014. Please welcome my next guest, Scott Zucker, partner with the law firm Weissman Zucker. Scott specializes in business and commercial litigation with a special focus on the self-storage industry. Thanks for joining us today. We appreciate you being in the studio.
Well, thanks for having me back, Michael. I appreciate it.
Yeah, thank you. And, first thing I'm curious about is how your practice has changed over the years. Are you, we did have some distress and some workout work. How has your practice changed more recently?
Well, actually, I've been pretty lucky because I got involved in the self-storage industry actually when I started my practice back in the late 80s. Mm-hmm. So I've been through a couple of the recessionary periods with the self-storage industry, and we've seen, as Mike Scanlon talked about, the resistant effort of the industry with regard to their ability to fight back against sort of recessionary times. We've had the time where we've helped facilities build and grow and consolidate. We've also had times where we've helped them do some workout and restructuring. So we've been there through the good times and the bad times, and now we're really back in a good time.
Yeah, so you're not doing any more workouts and problems?
No, I think the banks have been pretty good about working with these facility operators, and as you've heard before, is we've been on the low end of the default rates for the commercial industry.
Yeah, okay. And let's talk about acquisitions a little bit, Scott. I mean, what are some of the more common mistakes that investors should avoid when they're acquiring these properties?
Well, what's interesting about self-storage is they're buying the properties and they don't get estoppel certificates from the tenants because the tenants have their property in the units, the doors are locked, they have the key, so they really don't know what's in the units. They need to know who the tenants are. So one of the things that I really push for investors that are buying properties to look at is to do an audit of the property and look at the leases and make sure they have a lease for every unit, and therefore have a good sense of what's going on in the facility by knowing who the tenants are.
And I guess you also want to look at the payment records, right? And see are they paying on time.
Right. Well, that might affect the price if they're not paying on time, but they really need to take a good look at the facility with regard to the maintenance records, certainly look back at making sure the property's in zoning compliance, but they're really looking at the property as a whole, an environmental sense to what's happened on the property, who's using the property. A lot of these properties are for storage of cars and boats and RVs, so they have to make sure that the property is clean or know what they're getting into before they buy these properties.
So there's possibly more environmental issues to look at than a typical commercial real estate property, right? Because of these vehicles and things.
Yeah, I think it's part of the phase one and phase two sort of analysis of any good due diligence on acquisitions of properties. Mm-hmm. But we counsel folks to take their time and look at the issues with respect to what they're buying. Like you said, look at the rent rolls, and really need to do an audit of looking at what the leases correspond to the units that are being rented, and making sure that the management of the property, whether they're going to continue with the management that they're using or bring on their new managers, had a good sense of what was going on in the property.
Do investors in this space in their due diligence on an acquisition, do they go through every storage unit? Or
no, they can't.
They can't.
That's the point.
Oh, I see.
See, the tenants lock the space. They keep the key.
So you don't know if they're using it or not.
Right. Well, the best tenant has always been to rent the space and not put anything in there. But
if they're paying, you're right.
Yeah, but certainly they don't know, and that's why these sort of audits of corresponding leases to the units is pretty important.
Okay. And they also want to check out the access to the property in the roads around it and accessibility, right?
Right. We've counseled operators for years to make a good effort of looking at the DOT plans around the properties to make sure that the curb cuts are there for them to access the property, that trucks can get onto the property. One of the things that people sometimes miss is the fact that if there's a lot of development in the area, how the road access could be affected. And access into a property for self-storage where people are moving goods is really important. We have moving trucks moving in and out of properties all the time to store goods. So that access is really important. That's a good point.
Okay. So I guess you want to look at other permits that are being pulled maybe to build competing properties.
Yes. No, absolutely. Another key ingredient is looking around what's going on and seeing what other operators are doing to expand their own properties and having permits to construct and expand, or for other future competitors who have plans already in the books to build properties down the street. A lot of folks have to look within that 5-mile to 10-mile radius to see what sort of competitors are out there.
Okay, and let's talk about some mistakes that operators should avoid, or managers and owners during ownership.
I hate to say this, but I probably wouldn't be in business if operators did a perfect job with the operations of their facilities. I work with operators a lot, especially on training managers and trying to do their best job with regard to how they rent these facilities. One thing that a lot of people don't know is self-storage is a statutorily driven business. There are statutes in 48 states and the District of Columbia as to how you can operate a self-storage facility, primarily with respect to what happens when a tenant defaults on their property and how you can inevitably sell their goods to recoup the lost rent. It's a self-help remedy by sending notices and advertisements, very much like a warehouseman would sell goods for a defaulting tenant in a warehouse. There is no court procedure in most states for a landlord to go against their tenant to sell their goods. They can literally advertise the unit and sell it. I mean, this is sort of a la Storage Wars and Auction Hunters, the things you see on TV. That is a way of the landlords to create a remedy for their sales.
So if I don't pay the rent on my storage space, they might sell my boat trailer, right?
They might, and you got to pay your rent, but you'll get notice about it. And that's one of the things that's happening in the industry is pretty exciting, is they're modernizing a lot of the lien laws around the country to make it easier both for landlords and for the benefit of the tenants.
What are quickly the typical notice provision to a tenant that's non-paid?
Well, in most state statutes, the notice provisions are going to be some sort of preliminary notice by regular mail, then ultimately a notice by certified mail, and as we'll talk about, I'm sure some of the modernization of these statutes will be by email. Then there'll be advertisements in the paper, and then ultimately a sale at the premises to sell the goods.
Okay, so as a tenant, you'd have to be not paying attention to not know. That's
yes,
right.
Yes.
All right, well, stay tuned. We're going to have more tips on self-storage, investment, and operations. I'm Michael Bull, and this is the Commercial Real Estate Show. We'll be right back. The Commercial Real Estate Show is brought to you in part by your friends at Bull Realty. When your business requires proven performance, visit bullrealty.com or call 800-408-BULL. Welcome back. I'm Michael Bull, and you're listening to the Commercial Real Estate Show. Hey, thanks for sharing the show on Facebook and LinkedIn and Twitter. We sure appreciate it. Well, our show today is called Self-Storage 2014. We're talking with Scott Zucker, a lawyer who specializes in the self-storage space. And Scott, let's talk about what are some of the hot legal issues right now in the self-storage industry.
Michael, it's really an interesting time in the industry because we're seeing a shift in the statutes around the country. This is not just regionally. This is now a movement across the country to update and modernize the state self-storage laws that apply to self-storage operators. We have changes in using email for notification to tenants for the lien sales, as we talked about.
So you can't not use email now, but you might be able to later.
Well, there's already 18 states that now allow the use of email. Now, there's certain regulations that go along with using the email for notification, but I mean, that's a significant shift already. Almost half the states now allow email notification to their tenants, and we found that's really helpful because a lot of tenants who are in transition using self-storage will not have a permanent physical address.
That's a good point.
And we've also noticed that for a lot of tenants that are in the military that are using self-storage, we're much better able to communicate with them via email to resolve their payment disputes.
And in those states where you can use emails notification, was it have to be at certain times and they're more likely to see it and that sort of thing?
No, I mean there's always a timeline that goes along with the email notification, so they have an opportunity to cure their payment.
But you can't send them the email at 3 a.m. in the morning.
You know,
right?
It's funny, the statutes don't even talk about that, but I'm not usually checking my email at 3 in the morning. Hopefully most people won't be woken up by email.
Yeah.
But it's interesting because I think what you see is a trend to update these state laws and make it easier both for the landlords but also for the benefit of the tenants, so that now they're getting their notices via email since most people use email. I know the National Association even did a survey and study on the fact that most people will receive their notices via email rather than certified mail.
Okay, and what about towing my trailer if I don't pay?
You're worried about that trailer, I can tell. I hope you're paying your rent.
I hope I'm paid. I better check.
Yeah. It's interesting. One of the things that happened in the self-storage industry is not only the storage of goods inside units, but now the ability, based upon zoning rights, to store cars and boats and RVs, which has actually been a benefit for a lot of areas where their subdivision covenants prohibited the storage of the cars and the boats on the properties at the homes. It may have happened in your neighborhood while you have to store off-site.
Yeah.
So now they have the ability to do that. whereas self-storage operators are not really good in the title business of getting new title and selling the vehicles like a lot of towing companies are. Now you have statutory provisions in a handful of states that will allow the cars and the boats and the RVs to be towed off after a certain default period and let the towing companies handle the proper sale through the DMV or the Department of Watercraft.
Okay. And how about advertising of the stuff you're selling?
Yeah. Well, again, it's very interesting that you realize this revolution of the internet and using that as an information means for both tenants and for landlords. Mm-hmm. So now the number of states will allow you to advertise in lieu of putting it in the local newspaper, will allow you to advertise the sale online so people can see the fact that their units are being sold online and have better access to see that there is a risk of sale and then pay their bill and avoid the sale.
Okay. And what's a final hot topic legal-wise for this industry?
It is interesting that we have these modernization issues going on with the lien sales, but I will tell you that it's not just the state laws that are really important for operators to be aware of. There are federal laws that apply to self-storage operators as well. Americans with Disabilities Act applies. Federal communication laws apply to how operators work with their tenants. So unfortunately, operators need to be educated about the laws, both for their state and federal law, and we really push the resources of the national associations and the state associations to go out there and learn about your state law, go to these sessions, take the training to make your managers and operators better at what they do to avoid liability. I counsel more than anything in these sessions, avoiding liability, avoiding these risks by being better educated.
That's good. Well said, Scott. Thanks for joining us today.
Thanks, Michael. I appreciate it.
For more information from Scott, visit wzlegal.com. You're invited to join us next week. We have a great show in store for you. My guest is Les Atkins, and we're going to talk about social media strategies for business. Thanks for joining us today. I'm Michael Bull. Until next week, be sure that you always lead, learn, and laugh, and join us for the Commercial Real Estate Show. The Commercial Real Estate Show is brought to you by Atlanta Office Liquidators, new and used furniture liquidators, France Media, publications and conferences, and Bull Realty Commercial Brokerage, a great place to do business. For more information on these companies or to access additional podcasts, videos, or blogs, visit commercialrealestateshow.com.